This is an important bill for the Parliament to consider because it deals with and the very concept of bail deals with two conflicting principles and values we have in our justice system. The first is the presumption of innocence, and that is that somebody who is accused of a crime, somebody who's charged with a crime, prima facie has the right to be treated as innocent unless and until they're proven guilty in a court of law. On the other hand, there's the competing interest of community safety and protecting the interests of the community in being safe from people who have been charged with, in some cases, very serious crimes.
Our government fully recognises the need for action to ensure that our bail system addresses the over-representation of Aboriginal people in our justice system. And the reforms put forward in this bill seek to work towards this important goal.
This is about getting the balance right. We've seen a number of changes to bail over the past decade, and the acknowledgement by the government and by us in the opposition, I think by the whole chamber today, is that we didn't get it right in 2017.
This is just one step in the journey we must take to ensure that a death in custody never happens again. Over the past decade, there's been a significant increase in the number of Victorians remanded in custody. They've not been convicted of a crime and in some cases stand accused of minor non-violent offences.
We've seen lots of evidence where that spirals further on a downward slope and it doesn't do certainly society, community, anyone any good, needless to say the person that has committed that offence.
I'd like to acknowledge and recognise the advocacy of the family and the community of Ms Veronica Nelson, a strong Gunjamara, Jajawurrung, Wiradjuri and Yorta Yorta woman who tragically passed away while she was on remand. The details surrounding her death are well known, a tragic death and a story that highlights many of the ways our system needs improvement.
Without consequences, the antisocial behaviour only reinforced the community and safety. As I said, it is really compromised.
So if a person is charged with a serious offence such as murder or terrorism or rape or assault, only under the most exceptional circumstances can they be given bail, and that's common sense, that's reasonable policy. However, we don't want laws in Victoria that result in the over-representation of children, women and Aboriginal people who are on remand and locked up in custody.
The bill already provides those that apply to manslaughter, homicide by firearm, arson causing death and culpable driving causing death. But we'd like to see rape by compelling sexual penetration, sexual penetration of a child under the age of 12, aggravated home invasion, aggravated carjacking, aggravated burglary, armed robbery, and causing serious injury intentionally in circumstances of gross violence.
We've listened to First Nations advocates and communities, and the Greens have advocated for bail law reform for nearly 5 years in this place, since I was first elected. But my relief is also qualified because I know we can do better than this, better for Veronica Nelson, better for all First Nations people, and better for all Victorians.